Welcome to the first Guiding Cases seminar. My name is Mei Gechlik. I'm director of the China Guiding Cases project. A few years ago, I went to attend a conference organized by the students here, and then there was a panel titled The Rule of Law in China. The moderator did a fantastic job. He asked very good questions, had wonderful interactions with the panelists. I was impressed. A few weeks ago, I learned one thing. This moderator continued his support for the students here. And they're going to have another conference on China. The passion of this moderator remains the same. Still very passionate about talking about China. But then this time, he seems to be less idealistic because the title of the conference is The Rule of Law with Chinese Characteristics. When I thought about organizing this event, First Guiding Case Seminar, I immediately thought of him, inviting him to be the moderator tonight. I'm very happy that he quickly accepted the invitation. His name is Yabo Lin, partner of Sidley Austin. Thank you, Yabo.
Thank you, Mei. Do we need to use the mic? Can you hear me? Thank you. It is a great program to allow people sharing the same passion on case law and the differences between what China is trying to do and what the U.S. and common law system have been trying to accomplish. And May, I would like to applaud your efforts since 2012, right?
Since 4 years ago.
4 years ago, putting together the analysis, the translation about the China guiding cases issued by the Chinese Supreme Court. I assume that everybody has some general background about the guiding cases. So if you know about the Supreme Court of China program on guiding cases, maybe you can raise your hand. So a little bit of background might be appropriate when I moderate the panel. But we have a very distinguished panel of speakers today to share thoughts and analysis on this subject. So of course we have Mei, the founder of the program, and Jim McManis, who is a character in Scott Turow's book. And is a dear friend of mine. He is the founding partner of the law firm of McManis Faulkner in San Jose. Jim asked me not to tell you that he has been practicing law for 40 years. He is actually
47, actually.
47, okay. He's a graduate of Stanford and then Berkeley. When I first met him quite a few years ago, he said that he went to a state school. And of course, he's very proud of Stanford. One thing that I would like to highlight, Jim, in terms of his experience, is that he is not only a legendary trial lawyer. Obviously, he is an authority on trial and cases. But also, he has been the chairman or co-chairman, if you will, of a very important program called International Academy of Trial Lawyers China Program. And Jim, maybe you can spend a little bit of time talking about that as well. So Jim has traveled to China very extensively. He is one of the most well-connected people in the Valley when it comes to the legal community in China. He has, students from basically all the Chinese agencies who has come to this program to receive training, observations, etc. And to Jim's left, we have Jason Hao. Jason is currently a visiting scholar over at Stanford Law School. He was at the People's Congress, the National People's Congress in Beijing as a section chief, writing law that will affect people's life, affect government, affect companies. For example, the amendment to the civil law in China, or civil code in China, was mainly drafted by Jason. And Jason, I believe, has been at the Stanford Law School as a visiting scholar for a year. So it's very good to have his insight as a legislator in China on the case law subject. Maybe I can start with you if you don't mind. Looks like a lot of people in the audience are not too familiar with the guiding cases project. Can you talk a little bit about what this is about, and then also why you started this, and how this will affect and impact the rule of law in China?
Thank you. Well, this is a great question, and you should not feel bad, because a year after guiding cases, a year after guiding cases were released, the first batch, I went to a court in China, and then talking to maybe more than 100 judges, Chinese judges, and then they introduced me as the founder and director of the China Guiding Cases project at Stanford Law School. So there's a banner, okay? And then at the very beginning, I asked them, before this seminar was announced, how many of you ever actually heard of guiding cases? Guess how many people raised their hands? They are Chinese judges. Less than 50%. So you shouldn't feel bad. So now let me actually give you an overview. In October 2010, the Supreme People's Court, the highest court in China, issued a rule on guiding cases. At that time, not many people actually noticed that. And for some reason, I was doing research, I came across that, and then I was very excited because I have been spending my whole, academic career focusing on judicial reform in China. And so then when I actually read through the provisions on guiding cases, one particular provision captured my attention, Article 7. So basically the gist of it is, from now on, the Supreme People's Court will issue some guiding cases, some representative cases as guiding cases. And then according to Article 7, is required, they actually put it this way, subsequent courts handling similar cases should refer to guiding cases. So, I'm very, very curious about this provision, should refer to guiding cases. So I approached a few senior judges at the Supreme People's Court. I asked them politely but directly, are these cases going to be binding? And then, so this is like one senior judge actually answered in this way, of course not. But if they are not followed, there will be serious repercussions. So the first part of the answer, so exactly, I had the same response, but then I didn't actually smile immediately. I knew that something important is happening. So the first part of the answer indicates that this is the formal response they had to give, because Chinese legal system is based on civil law tradition. And then they are not supposed to have any binding precedents. And then but the second part of the answer is the real answer, is actually they expected these cases to be followed closely. So that's the reason why I described these guiding cases as de facto binding precedents, de facto, in fact. And then, when I got this reply, I immediately approached a few law professors interested in China, and then the dean. And then I was very happy that within a very short time, I raised some seed money to start the project. And I quickly put together an advisory board. So it actually happened in February, March 2011, at the time when they didn't issue any guiding cases. So I actually, prepared a project like that. And then I reached out to 40 advisors, 40 distinguished experts in Chinese law, and also some judges from China and also from U.S. Supreme Court. They agreed to be honorary members of the project, honorary advisors. And then I also invite some distinguished China law experts in United States, in mainland China, Hong Kong, etc. But the real work actually should be done by our own team. So at that time, we only recruited Stanford Law School students. But then very quickly, we noticed that we have too much work to do. So that's why we extended the opportunities to anyone interested in China law. And language ability certainly is an asset. but it's not a prerequisite. So very quickly, I can tell you that now I'm very proud to have a global team of 150 members around, in different parts of the world. They are primarily law students, top law students from different law schools in the States, in China, Hong Kong, some even in Europe, and then junior attorneys from law firms. And so they're doing a lot of good work. So I will actually leave it like that because you probably have a flyer about China Guiding Cases project that summarizes our major products and our major achievements. So thanks, Yabo.
Thank you, Mei. So Jim, the topic of our today's talk is why China's guiding cases matter. So Jim, you have been traveling to China in the last 4 years as part of the IETL China program, and you have met a lot of people, very high-level people from various agencies, including the Party School, the People's Congress, the State Council, Legislative Office. Why do you think in a civil law country like China, case law matters?
Well, I'm going to stand up, if I may, because I'm used to speaking on my feet, and I hope you don't. Nobody's bothered by that. First of all, I want to thank you all for coming. I'm amazed that there's this many people interested in this subject, and I think it's a tribute to you, Mei. You got a great turnout like this. A young lawyer asked me during the reception before we came in here. She said, I've looked into your background on your website, and I'm curious, what are you doing here? And I asked myself that question driving up here from San Jose, but it's nice to be here. I will answer the question that Yabo put in this fashion. I think the work that Mei is doing in this China's Guiding Cases area is very, very important work. Because, it's said that China is following a civil law pattern, that it's not so much a common law country and what have you. And I'll leave it to the professors to define exactly what is a precedent, what is not a precedent. They seem to have plenty of time for that sort of thing. But basically, I think a fundamental principle of justice and fair play is that like cases should be decided in a like fashion. So if the facts are A, B, and C, and the result is X, Y, and Z, and you get another case that has those same essential facts, A, B, and C, the result ought to be the same. I think we'd all agree to that. It's just common sense. And although they say that civil law countries are different than common law countries, and they of course are, the difference is really at the end of the day is that the judges, the courts in all systems try to decide cases in a similar fashion so that the outcome is predictable and fair and even-handed. And that's important in our daily life in terms of planning. We want to know how you write a will, a contract, do a business deal, and you've got to be guided by what the law is and know that if the law is a certain way in this case, if your case is the same, it's going to be the same way. That's in a nutshell. In the common law tradition, judges write lengthy opinions. They cite other cases. Civil opinions are much briefer. Academic commentary is welcome. But at the end of the day, I submit it's the same basic quest for predictability and just results. Same cases should have the same outcome. There it is in a nutshell. Now, China, Napoleon said about China, China is a sleeping giant. Let her sleep, because when she awakens, she will shake the world. And China has awakened, and she's shaking the world. And in answer to my young friend's question, what am I doing here? I want to be there. I want to be there at this moment in history when a lot of important things are happening. And any way that we can help, happy to do it. I got my undergraduate degree here in history, German history. I was a Stanford student. And then I went to the state school for law. It's up in Berkeley. Came down to San Jose, and I prosecuted cases 3 years as a trial lawyer. And I started my own office 43 years ago as a criminal lawyer, defending those cases. And then other lawyers asked me to try their cases, and I got into civil cases. And all I do is try cases. 12 years ago, I was honored to be elected to the International Academy of Trial Lawyers, an organization of trial lawyers described as the top 500 lawyers, trial lawyers in the U.S., and many lawyers from overseas. 5 years ago, I was honored, my wife and I were honored, to be asked to take over the China program of the International Academy of Trial Lawyers. China program was founded in 1994 when the United States ambassador to China, J. Stapleton Roy, asked Raymond Tam, what you would call an ABC, American-born Chinese from Hawaii, to form a program to help China develop its law. And as we know, during the Cultural Revolution, China had no law. Chairman Mao said, "We have the rule of man. Why do we need the rule of law?" And there was no law in China. After that madness subsided and Deng Xiaoping became the leader in China, and later Jiang Zemin, Mr. Jiang went to a man named Lu Chu and said, he knew him from student days in Shanghai, he said, "You must go to America and learn about law." And Lu Chu said, "What is law? I don't know what law is." And Mr. Jiang said, "Neither do I. You will go to America and you will learn law and you will come back to China and teach me." And Lu Chu went to Columbia University and he studied law. He studied it with a Chinese-English dictionary in one hand and a law book in the other. And he learned law and he came back and later became the advisor to our China program. And when he retired a year ago, I was honored to have Lin Yabo take over as advisor, and he traveled to China with my wife and me in the fall. We go to China every fall. The government nominates 25 of its top lawyers, principally from the Legislative Affairs Office of the State Council, the National People's Congress. This is a graduate of our program. And the Central Party School. We interview these candidates and we select 10 of them and we bring them to America in May. They're coming in 3 weeks. They'll spend a week in San Jose at an orientation learning about the legal system of America, the culture, the way of life, and then they will go and live with the families of American trial lawyers all over the country for 2 weeks to understand what it is to be a lawyer, a trial lawyer in America, at home, at work, and what have you. They'll come back and they go back to China. And we have had over 200 lawyers in the life of the program. I was honored last fall in Beijing when we had a dinner. Vice Minister Hu Keming said to me, "Your students are all over China." And they are. I love China. And it's the most exciting place in the world. And I think that the work that Mei is doing is helping the China legal system develop is very, very important work. It's got a long way to go. The guiding cases adopted by the Supreme Court of China, the People's Court, I think it was 2012, unless I'm mistaken, 2011?
44.
There are 44 of them now, but it was 2011 or 2012 when they issued the China Guiding Cases Project. So it's just started, and there are 44 cases. Last year, the United States Supreme Court wrote 75 opinions. The California Supreme Court wrote 80 opinions. And that's 2 courts of last resort As you know, we have 50 states, so there are 49 other Supreme Courts opining about the condition of American law in various states. So it's a long ways to go, but it's a start. And I think these guiding cases are going to become very, very important. And, you know, when I was chuckling to myself when my friend Mr. Lin said, or maybe it was Mei, it said that, well, these are not mandatory, but they should be followed. And if they aren't, there will be serious repercussions. That, to me, is such a Chinese thing to say. I have said to many of my friends in China, I don't think there's a word for yes or no. A simple yes or no. If I ask a question that I think is going to get the answer yes, it's no big problem. No problem. Unequivocally, yes, you can take it to the bank and put it in writing. No big problem. And if it's not something that the person wants to do, well, that would be inconvenient. So you should follow, you should refer to these cases, but if not, serious repercussions. I think we all know what that means. What that means is these cases mean exactly what they say. Guiding cases. The word guiding means exactly what it says, guiding cases. Now finally, before I sit down, and I apologize for ranting and raving. You get to be my age, there's not much left except to talk. But here it is. I was asked by Mei about, did we ever have in our program judges? She's verifying. She asked me that question. And I gave it some thought, and there was one judge in our program many years ago. I'm going to tell you a little story about this judge. This judge was sent to Colorado for her 2 weeks at an American Trial Lawyers Home, Denver, and she stayed at the home of John and Charlene Purvis. John Purvis is a wonderful trial lawyer, practiced for many years in Denver, a lovely wife, and this judge was at their home. And we have had a rule in the program since it was started in 1994 that the delegates, we call them delegates, the government lawyers, may not travel in the U.S. unescorted. And there are reasons for this. We take our responsibility to host these people very seriously. America is a dangerous country. We've all seen some of the sad cases where someone's been attacked. We don't want that to happen. So it's a rule. And when we interview our candidates in the fall, we ask them, this is a rule. Can you follow that rule? Oh, yes, yes, we can follow that rule. Okay. Well, this judge was in Denver, staying with John Purvis. She decided that she wanted to fly to Los Angeles to see a friend. And there was no reason why she needed to be escorted. After all, she was a judge. And so she was going to go to Los Angeles. And John said, you can't go to Los Angeles. It's against the rules. And he was standing at the bottom of the stairs in his home. She was standing at the top of the stairs. And he was saying, Your Honor, you can't go to Los Angeles unescorted. And she looked down at him and said, Purvis, you bastard, I can do anything I want. I'm a judge. Now, the lesson I took from that is that judges are the same all over the world. Any event, John, good trial lawyer, he said, we'll see about that. And he called Lou Chu. Remember Lou Chu? I don't know anything about law, neither do I. Go to America, come back and teach me. So he called Lou Chu. Lou Chu called Beijing. Beijing made a call to the judge. No more problems. She didn't go to LA. She accompanied the group back to China, and no one's ever heard of her since then. I don't know. Draw your own conclusions. But in any event, it's been a wonderful program. It's a program of which we are very proud, and I will do anything I can to support Mei's work. My wife and I have a foundation, the McManis Y China Foundation. My wife's Swedish. Her last name is Y. when we were engaged, I was at that state law school about to graduate. My mother said to me, whispered, "What's your fiance's name?" I said, "Why?" She said, "Well, I want to be able to introduce her to people, and what is it? So what is her name?" I said, "Well, why? Don't be difficult. I told you." Any event, we have a foundation. We are honored to support this evening's event, and the China program of the International Academy of Trial Lawyers is also supporting it. And so I hope you enjoy this. I hope you get something out of it. And if anybody has any questions of me, you can find me. It's McManis Faulkner. That's the law firm in San Jose. And my young friend who wondered why I was here, she found me. If she can, you can. And I'm happy to do anything else you would like me to do, but that's all I got to say right now. Okay?
Thank you, Jim.
All right, is that fine? Is that okay? All right.
So, Jason, why are you here, Jason? You're a legislator.
No, I'm not a legislator. I'm just that's in your Congress. I'm just a legislative attorney or counsel.
Right.
I'm not the politician.
Right.
So
No. I mean, you work for the legislative branch.
Yeah.
So, case law is different, obviously.
Yeah, it's different.
So,
yeah.
can you give me maybe one or two examples where case law has had an impact on the Chinese judicial system?
So, first of all, good evening, everyone. First of all, I'd like to thank Mei for inviting me so that I can sit along with you and Ben. Yeah, it's my honor. Before I explain the importance of the guiding cases, I'd like to share some basic ideas about China in terms of a legal system. Because I say so many of the audience are not familiar with the Chinese law system. So first of all, China, as Mei mentioned, is a typical civil law country. So in our country, the People's Congress, the National People's Congress, at the top legislature, is designed to pass all statutes, and the Supreme Court and the other courts at the judiciary must follow the statutes, and is not allowed to create new law. So it's very different from here at the common law jurisdiction. Second, I will say China is a very special civil country because I think maybe the largest civil jurisdiction in the world. So you can see the map. So China is so big, and China is also one of the fastest growing countries in the world. So no one, including me, can predict exactly where China will be in the next. Tomorrow, even next month, next year, I cannot predict. So, and China is going so fast. But if you look into the territory, if you visit China, some places, you will find there's a remarkable imbalance in development between the East and the West. We also have a well-developing prosperous east part of China. You can see the Shanghai, just like New York, it's very good. But unfortunately, we don't have a very strong, economically strong, the west part, as in California. Even we have lots of real sand hills there. And every part in China is changing every day. So what I said that is just to show you how the big challenges we legislature has been facing in the past decades, even today. But at the Congress, at the legislature, we must have to make law for the country that supposed to be applicable to everywhere in China within its territory. And we also make laws that are supposed to survive the fast growth in the of China in the 21st century. So it's a very big the challenge to us, but we have to do my work. So based on my own experience as a legislative attorneys, we find a new safe way that use more broad, general, even vague terms in statutes. So the good point that will make law generally applicable to everywhere in China. But the side effect is also obvious. To there left so many shades of gray in the legal system for practice. So this is a problem. In addition, as a law drafter, we also use some words commonly found in every statute in every state, such as the reasonable and necessary, a good faith or bad faith, or a probable cause or public interest. So I think you will agree with me on that. It's very hard to define these terms in the statute. So we can do our work very easily to use such kind of broad or general words. But the judiciary must have to interpret the laws in order to decide the case before them. So you can imagine, due to the broad prescription of the statutes, the big difference of the interpretations are just as to the same article. So you know, in any country, the uniform legislation requires uniform application. So our Supreme Court has made some efforts. So primarily, they are allowed to issue some detailed judiciary interpretations to a law. But the judiciary interpretations, just if you have some idea of China law, is said in Chinese, 司法解释. The judicial interpretations do not take the form of the rules laid down in one specific case. It's more look like a sub-legislation. It's a detailed legislation. But they will find, and the drafters, they are all the senior justices in the Supreme Court, but they also run into the same difficulties as we did. Some rules in the judicial interpretations work well in some places, but do not work well, even very poorly in other places. And some rules appear obviously outdated just a few years ago after they were released. So recently, just you mentioned, in a couple of years ago, in 2010, the Supreme Court tried a new approach, that is the guiding cases. So in that cases, if you can interpret the law, just like the cases in the United States. So in these cases, the court interpret the law and just as the guidance for the lower court to how to interpret the law and how to apply the law. So I'd like to mention the case here. It's the guiding case number 33. Briefly, this case deals with two main issues here. One is about the Article 52 of the PRC contract law, and another issue is concerned about the Article 59. So the Article 52 is about the contract will be nullified because of it was entered into by the parties with bad faith. Bad faith. So yes, the contract law is the first law I took part in drafting 20 years ago. In that law, we didn't define the term bad faith or even the good faith. It's very hard to define them. So in this case, the court trying to interpret the word, what is the bad faith in the very case. So if you read the case, you will find generally it requires the transfer of the property at a clearly unreasonable low price between the party and its affiliate company. And the second, and the affiliate company had the knowledge of such a transfer at a so low price will impede the party to pay off his debt to the third party. The third party here in the case is the plaintiff. The plaintiff. So you can say, just like the American way to interpret the word the bad faith in some circumstances. I don't think the interpretation of bad faith in the case will be applied to any other the cases.
So Jason, sorry for interrupting. So has guiding case number 33 been followed by other courts in the lower courts? And when lower courts decide cases, can they cite the case, the guiding case?
I don't think so. They can directly apply the case here as a precedent. Maybe they will learn how to interpret the broad words.
So they will just write their analysis following the guiding case, but they are not going to refer to the guiding case.
Yeah.
May I say a few words? This is exactly what we are doing. We, apart from translation, okay, we provide the English version of all of the guiding cases, and then we also invite leading experts, including Chinese judges, foreign judges, to write commentaries. Another actually product that we produce is to follow the subsequent development of each guiding case. And I think I can provide you with an overview about our research. So far, we have found about 200 subsequent cases that mention guiding case this term. And then, I quickly actually review them. I had nothing else to do. I quickly review them. And almost half of these subsequent cases that actually mention the term guiding case turn out that it has nothing to do with the 44 guiding cases we talked about. But then they use this term to refer to another thing, totally irrelevant. Or maybe they mention this term incorrectly. So this is totally out of context. So we have all these, 100. And then the remaining 100, okay, so then we found the most, one guiding case number 24. There are about 42 to 45, if I remember correctly, subsequent cases that really refer to guiding case number 24 explicitly. And then we've also very interested in, to what extent actually guiding case number 24 also mentioned implicitly. So right now we haven't actually have the number, but for that particular guiding case, 45 subsequent cases actually mention guiding case number 24. And that case is about personal injury in a car accident. Apparently, this is a big deal because they actually claim compensation, etc. And I would say, the latest, because guiding case number 33 is a relatively new guiding case, it may take time to evolve. So my guess is that so far we haven't seen any subsequent cases that refer to guiding case number 33. But usually we actually give maybe a year or a year and a half, then we may be able to see some subsequent cases. But to elaborate on one point that actually Yabo asked is, well, how do they cite? Sometimes they actually, I think, Jason's intuition is right. Just like we ask judges, do you feel comfortable to refer to guiding cases? Many of them say, well, because we actually conduct some surveys on the ground to ask judges. Many of them say we don't know how to do it because, well, based on the rules on guiding cases, there's no clear explanation how they should refer to guiding cases. So as a result, one type of response is that we want to, but we don't know how. And we're talking about a Chinese legal system. And then this is a legal system that judges are not even allowed to cite constitutional provisions. As you can imagine, they are very guarded about what they can cite, what they cannot. So giving that kind of response is not a surprise. But then I was actually very pleased to see that among those cases that I review, some judges actually refer to guiding case and then identify by name or by the guiding case number explicitly. And that's very encouraging. And then some only refer to similar logic, like the legal principles basically summarized by the Supreme Court when they prepare the guiding case, which is actually included in the part called main points of adjudication for each guiding case. Then they only refer to those expressions, avoiding mentioning the name of the guiding case. But now this is actually one more interesting observation is that at the very beginning when I thought that, well, I would actually want to do something more to actually train judges, right? Because if they refer to guiding cases, that will be really a major breakthrough. But later, after I review these 200 cases, I have another perspective. It looks like the most important parties to be trained should be attorneys. Because if the attorneys representing the case, representing the parties really refer to guiding case, saying that, making his argument, we think that this case is relevant, it's similar to the pending case, then the judges will feel obligated to respond, whether that's indeed the case. So we actually come across some situations like that. But some other cases the judges just ignore without actually answering whether this case should be applied or not. So I find this so go back to the fundamental point is, guiding case is only the first step. We have a lot of work to do is to track the subsequent developments. And that's the reason why we need the global team of so many members. So I want to emphasize one thing, because Jim and everyone here always say Mei's work. I want to emphasize it's not just Mei's work. I'm not being humble. It's all done by the team.
So Jim, you have a comment.
I have a prediction. We've heard a lot of commentary from our friends here about guiding cases. They're cited, they're not cited, maybe this, maybe that, what have you. My prediction is there will be a case, I don't know when, but there will be a case in which someone is going to take an appeal. And it's going to make its way to the Supreme People's Court. And one side is going to argue they didn't cite the guiding cases. They didn't follow the guiding cases. The other side is going to argue, you're not supposed to do that. That wouldn't be right. It's a may, not a shall. And then my prediction is the Supreme Court will issue another guiding case. And that guiding case will say, this is what you got to do with guiding cases. Yes, no, or whatever. And my further prediction is they're going to say, we issued these guiding cases for a reason. There's a reason the word guiding is in the title, guiding cases. And I predict that the guiding cases are going to become established. But I agree with Mei that it's going to take time. Turning to the common law tradition, where we have the principle of precedent and stare decisis, and I submit that's also present in a different form in civil practice, civil law systems. But the principles of precedence are relatively recent. The common law goes back hundreds of years, but it was only in the 19th century in England that cases were reported on a regular basis, and there was a record made of decisions that could then be cited and referred to in deciding other cases. Well, what is Mei and her group doing? she's basically facilitating a process of reporting these guiding cases, cases that have followed the guiding cases, whether they cited a guiding case or not. She is instrumental, and I'm using you, and when I say she, I mean all of your colleagues, instrumental in the development of the law in China. Because I don't care, with all due respect to the National People's Congress, how carefully you and your colleagues, Jason, crafted legislative enactments. They have to be applied in the real world to real facts and real people and real cases, and that's why judges are so essential. They're going to have to interpret the law as issued by the National People's Congress in a case-by-case basis, and to do that effectively, fairly, and to make China truly a country under the rule of law, not ruled by law. The guiding cases are going to be critical. And because of the civil law aspects of the Chinese legal system, I think involving the work of scholars here at Stanford, all over the world, and adding nuance and subtlety to these cases and these laws, it's very, very important work.
And also to add to that, to basically put the guiding cases into international context, right? So to make it a body of research and not to influence, I suppose, but to the outside counsel outside of China and also in-house counsel for international companies. If this body of guiding cases is only in Mandarin, it would be very hard for them to understand and access.
I couldn't understand them.
So with the translation and annotation is good for Chinese rule of law as well, because all these international lawyers will be able to use those guiding cases for their clients in China. So I know that we have 1 hour for the program, so perhaps we can go to the Q&A session. I think we're going to finish the program at 7:15, so I'm trying to run a tight shift over here. So maybe if you have any questions at all, please raise your hand. I think you're first.
Because we want to record the event.
So I'm Scott McLeod, and I'm developing a startup online university, and we would like to have explore the possibility of instructing in the fields of law in many countries and many languages. And it's like a little bit like Wikipedia in 288 languages, with MIT OpenCourseWare in 7 languages, including Mandarin, traditional and simplified. And I'm curious how a kind of, whether, for example, Stanford Law students who are Chinese nationals who come here, get a law degree, and return to China, perhaps you're one yourself, Jason, or perhaps you, Yabo, okay, could be potential instructors as graduate students or as graduates in something like group video, like Google Hangouts or MIT Unhangouts, to perhaps instruct further about guiding cases and their role as precedent as all of this unfolds. Could you imagine Stanford Law students as graduate student instructors working under Mei, doing such a thing in the PRC online, for example?
For free?
That's one of Jim's common refrains. For free?
Scott,
So, Mei, what do you think?
Well, Scott, this is a very interesting question. I can only tell you that recently Stanford has established the so-called Stanford Cyber Initiative. And then they just offer some funding opportunities to encourage, faculty members to reach out to other faculty members and student groups from different disciplines to create a project that will have impact on society using technology related to cyberspace. So I do have a plan to do something along those lines, but I cannot disclose that now. But then I want to tell you that we are very ambitious because, not because, well, we are ambitious to have a big name, but we do see that this is actually important to promote the rule of law in China through something. This is like a Jim and Jason and Yabo always say, guiding cases, this one is a tool, and this is an evolving system, okay? And it's really up to us how to use these cases. And that's why that's the moment that we have to do something together. And I want to actually promote more understanding through different type of technology. But we will actually have more discussion when I get funding, okay? And we will launch another product.
Thank you. I think you have a question, a gentleman over there. Oh, okay.
There's definitely.
Yes, hi, my name's Sidley.
Because we want to record, the Q&A. Thank you.
Make the mic higher. The highest.
It's a pretty small room. I do have a pretty booming voice. Anyway, hi, my name is Emilio Veronini. I'm with the California Attorney General's office. I also teach in China a course that compares Chinese antitrust law to U.S. antitrust law every summer in Beijing at the University of International Business and Economics. My question is this. So from an antitrust perspective, the Supreme People's Court has issued guidelines, but as far as I know, they don't have any guiding cases yet. I'm hopeful maybe the QQ versus, the Tencent versus Qihoo case might become a guiding case. But listening to how Xian talk about his experience, the question that I came up with is, do you have a sense on how the Supreme People's Court goes about picking guiding cases and how they decide when they're going to issue guidelines versus when they're going to use a guiding case to help the lower courts figure out how to analyze a given law?
I know the answer. Well,
Yeah, May I think?
may I?
Yeah.
Well, actually, after each guiding case is released, then maybe within a year, it depends, so there's no clear timeline, then the Supreme Court, the office in charge of guiding cases, will issue an article explaining the justification, the reasons for picking that case as a guiding case. And then they also talked about the process that they actually went through. Usually, for example, and according to the rules of guiding cases, they already actually provide some basic steps. Well, basically, if this is a basic level court, they think that they're very proud of this particular judgment, then they will actually report to the upper level courts level by level, and then recommend that as a potential candidate guiding case. And then finally, all these cases collected by the Supreme Court office in charge of guiding cases, and then they will allocate to different divisions like civil law division or maybe administrative law division to review these candidates and then see which one is really worth being picked as a guiding case. And then finally, the adjudication committee of the Supreme Court sit down, well, all these, that means president, vice president, and chief judges of different divisions will actually have a meeting to decide the final choices and then release them as guiding cases. I had the great opportunity to have dinner with a few judges in charge of that office. And then when I showed them, because I love numbers, I love languages, but also love numbers.
Sure.
When I showed them how I put together data to talk about the trends of these guiding cases, and I showed them, and then they were very excited. They said, well, this should be done by us. I said, well, you're very busy picking cases. Let me show you. So then that's the reason why they convinced me to produce a Chinese version. So I can tell you for sure that they have been following our work very closely. And they are actually very pleased that we're doing this work. Just like what Yabo said, because that helps them to promote their work through translation as well. As for antitrust per se, I don't know for sure how they will decide when they issue guidelines and when they pick guiding cases. We don't know.
They already have guidelines. I was just kind of curious about the interplay between that and guiding cases and how they may decide to go down one path versus another.
Yeah, I don't exactly know how they actually design the time frame for these two. Yes.
After listening to your explanation, my comment would be, don't hold your breath.
Anyway, thank you very much.
Thank you.
Up to the right there, Charlie.
Yeah, I think Chen raised.
Chan.
Yeah.
Actually, China is a civil law country, but I found that China learned a lot from the U.S. As Jim just mentioned, for example, Mr. Jiang sent his people to the U.S. to learn what is law. So, do you think that will cause some conflict because China is a civil legal system? If you learn something from the common law system and learn something from the civil law system, I understand maybe that's why we have such a tricky thing, the guiding cases, which technically are not binding but have to be followed. So
I can explain further about from the case, the guiding case 33. As I said, it's about the Article 52 and 59 of the contract law. So if further cases are concerned about the bad faith under the Article 52, I think the lawyers for the party and the judge will take into account what's the explanation in this case. And what's important in the Article 59, what's important is from the case you said, the case or the court just spelled out what we should say in the case, the application of Article 59. There is implied precondition, but we didn't write the condition in the article, but you can find out the case, the court spelled out that if the third party can claim the restitution from the contract, you must the owner of the interest during the contract is executed. So it's very important.
Well, let me footnote that in answer to your question. I think it's good to draw on many sources. The world becomes smaller and smaller. And, you know, it's very controversial in our United States Supreme Court, foreign law. And the conservative wing of the court says, well, we don't do that. We're Americans. That's not a good idea. And I've never understood that because, yes, of course, foreign law doesn't bind us. We're going to decide these cases as American judges and lawyers under American law. But we can learn from the foreign practice. I think similarly in China, they can learn from American practice. That's the premise of our program, the China program of the International Academy of Trial Lawyers. So one of the things we always say to the delegates when they come and they get the orientation, we are not going to tell you what you should do or whether our system's better. We're just going to tell you what our system is. And we'll answer questions and then you decide what's best for you. And so I don't think there's a danger for China taking things, the good from American legal practice, judicial practice, and leave the rest alone. I love Chinese characteristics. China should have what's best for China with Chinese characteristics. That's China. We do it here differently, but we've got a lot in common, and I think we can all benefit.
I want to add. I did expect to have questions like that, especially raised by Chinese judges. And in fact, that's exactly the reason why I have invited judges from Taiwan and Japan and Germany, all these civil law traditions. So I have an agenda. Use their mouths to tell me about their systems because it's civil law tradition. And I can tell you, it's already published, a piece of commentary written by a judge from Taiwan to explain the system in Taiwan. There's a set of cases decided by the Supreme Court in Taiwan. They actually call them binding precedents. Well, in a few weeks, we're going to publish another commentary written by a Japanese judge. Again, in Japan, they also have a certain set of cases, binding. So the point I try to make is that's the reason why I address the concern. Any jurisdictions, all these judges would like to handle similar cases in similar way because that gives you some confidence, right? Otherwise, they feel very nervous. So I think that, this is actually to address the concern that you don't need to draw a distinction, common law, civil law. In fact, other civil law jurisdictions already also practice something like that.
Hi, so my name is Aram. I'm a JSD student at the law school. So I wonder whether you can comment a little bit about the quality of these guiding cases. I mean, how do they apply the law? I mean, are there any law professors in China who might say that, some of these cases actually apply the law incorrectly or something like that?
Yeah, I think it would be a good idea for you to answer, Mei.
Well, for a person who has read all the guiding cases word by word several times, so I think I would say, in general, just general observations. I can be critical, but I don't want to, because this is hard, especially now I'm in the publication business. It's very easy to pick on several mistakes and then criticize. But in general, I can say that since the first guiding case and up to now 44, one thing that really impressed me is it's very consistent. Each guiding case, first of all, is only a summary. It's not the original full text judgment. It's a summary prepared by the Supreme People's Court, and each one has 6 parts: keywords, relevant legal rules, main points of the adjudication, basic facts, results of the adjudication, and reasons. I started studying Chinese law 20 years ago. Okay, and then at that time when I read the judgment, it's only 1 page or maybe 2 pages. Now, each guiding case, at least maybe 3 pages or even longer, especially all these later subsequent cases, sometimes 6 pages. Because of that background, so you can see that I already actually see that this is actually quite a progress. And in the past, I didn't see any reasons. Okay, now each guiding case has a reasoning part. Well, of course you can criticize. Oh, it's still only 2 to 3 paragraphs, right? But lately, if you look at the latest one, guiding case 37, a few pages talking about reasons. But one thing I can actually make some, comments is that because it's only a summary, then there's a problem. They summarize all the facts into 2 to 3 paragraphs, or maybe 2 to 3 pages, okay? Then does it mean that we cannot refer to the original judgments? Then, when you have a pending case, and then the judges need to decide whether the case is really similar to the guiding case. Based on what? Based on the summary of the facts, okay, provided by the guiding case, or based on the original judgment? Now, that's a very crucial issue. So that's the reason why, in fact, this is a step that will be taken by the Supreme Court. They are actually drafting more detailed rules on guiding cases, because the current rules on guiding cases very short, only a few articles. They're drafting, but then it's a very, very difficult task for them. They don't know what to do right now. And that's the reason why this is, because it's evolving. We, practitioners, scholars, should really work harder to help them have some opinions about them. So I would say, in general, it's a pleasant surprise. I find it actually quite impressive. And then I have my own preference, like the guiding case number 5 is particularly impressive. So go and then take a look. Mm-hmm.
Thank you, Mei.
This gentleman up here has got his hand up.
Hi, my name is Charles Shea. I'm a fellow at business school. I guess in terms of economics, there's nothing more important than the status of a variable interest entities in Chinese law. Billions are being traded based on the legal concept as to whether it's enforceable in China or not. So I'm just wondering whether that would make it possible to get some sort of clarification under guiding cases as to its precise legal status under Chinese law.
You mean the status of?
The status of variable interest entities.
Oh, it haven't. Yabo, you can say a few words because this.
So, if you go to the Wall Street Journal, I think it's yesterday's paper, in the B section, the bottom half of the newspaper has a very dedicated article about VIE. It's a very fascinating article. Obviously, it's a new phenomenon in China, studied by Sina, right? And I think it started to come into existence, I wanted to say 2000, or 2001 during the first dot-com boom. And now, because the Ministry of Commerce issued a new law about foreign investment in China, putting the VIE structure in doubt. So the common understanding, obviously there's no guiding cases on this issue. We don't know. So, but it is...
Talk about the draft foreign investment law, Yabo.
Right. So I don't know if everybody has the background about VIE. So internet business in China is off limit, basically, to foreigners. Okay. So be creative, lawyers and other folks design a interesting program to evade that law. So you have foreign investors, but they have a nominee shareholder in a Chinese domestic company. And through the domestic Chinese company, they would obtain what's called the Internet Content Provider License, or ICP license. And then they would do business. Amazon is one example, right? They acquired Joya to Joye.com, and then they changed them to Amazon, but this is a VIE structure. So they control the entity, and through all these control agreements, they control these entities operating, but it's only a control relationship. So for example, they will use a Chinese citizen, say Qian. Qian is a Chinese citizen, and Qian will set up a company for me, say Amazon, and Qian will sign an agreement with me to say that I completely control you, but you have the license to operate the business. The Chinese new law says, or is still in the draft form, says that we don't decide who controls this company by the ownership anymore. We decide that by effective control. So if Amazon controls Qian's company, then that company is a foreign company. Even though it is domiciled in China, it is a China incorporated entity. And therefore, Qian's license might be revoked. The problem is, I think the article used this word, you cannot walk on University Avenue without tripping over a VIE. So there are a lot of VIEs in Silicon Valley, meaning that the VCs use VIE structure in China to do business in China all the time. So how to solve that problem? I think it's very early for the judicial system to come into play, because the draft law is still not effective. It's still in the final form. Jason's former colleagues still need to codify that law, and they need to vote. And the prediction is maybe that will not happen in 2 years. If it happen at all, I don't know what will happen to the existing VIEs. One doctrine is that they will be grandfathered. Another doctrine is that they will be forced to divest, and then they will attract domestic Chinese companies and Chinese citizens to invest and increase the control level so that you will become compliant.
And all that means really is however they decide to regulate this at the end of the day, clever people like our person up here that asked the question will figure out another way to do it. And then we'll sooner or later have a guiding case on that subject, perhaps. That's what's so wonderful about life is that just so many things happen. And again, at the end of the day, everything, all these things about a control group versus ostensible owners, it's in the United States history, in the judicial. We've dealt with these problems, and China will deal with its problems, and it all goes on.
Any other questions? The fast track treaty. Oh, so the fast track is a negotiation authority to be given to the president to negotiate free trade agreements. I think you are talking about TPP, the Trans-Pacific Partnership Agreement, basically to counter China's rise. So basically, United States would like to sign TPP with Japan Korea, Southeast Asian countries, South America, Pacific Rim countries. But Congress is giving President Obama a hard time on this fast track authority.
Really?
Yeah. So with this fast track authority, the president can negotiate the treaty, but Congress still needs to debate and pass it. So take it or leave it. The Congress cannot change the provision of the treaty. No, you will not. Right? This is a U.S. law and U.S. treaty, and China would not become part of it. China has been excluded from this negotiation. So let's give a very big round of applause to our panelists, Jim, Mei has an acknowledgement to make.
Well, you can imagine 4 years ago, this woman just had an idea on Sunday afternoon. And now I see so many faces like a dream comes true. I particularly want to thank for your participation and thank Jim's firm and foundation and the China program, as well as Fu-Tech Game Foundation for supporting this event. Thank you very much.